Thanks for joining me again. We're doing a video series on Chapter 17 of the Code of Criminal Procedure, Family Protective Orders, Emergency Protective Orders in particular. And what we're talking about is how these orders get served, like who gets the notification of them. Well, the first person is going to be the person who the order applies to. That's usually going to be on their way out of the detention facility. They're going to get a copy of that order. Law enforcement's going to get a copy of that order. DPS in Austin, if you have a concealed handgun, is going to get a copy of that order. It's going to be forwarded on to the FBI. So there's going to be a lot of levels of this order being transmitted. The school, if any children are subject to that order, the school gets a copy of that order, and local law enforcement agencies, if the mom and dad don't live in the same area, they get copies of the order. So a lot of people are going to know real fast that this has occurred and that there are orders in place to protect that. And the fact of the matter is, the orders and the hue and cry to spread the news about the application of the protective order is to prevent further family violence. Now, I hope to God none of you ever faced with any kind of situation like this, but that's one of the reasons why all these little procedures are in place. And they're fairly automated by our state and local county law enforcement first responder authorities. And sometimes there's a hiccup here or there, but for the most part, the word is out on the street that there's a family that needs to be protected and that they're subject to an emergency protective order. Another thing that can come up during that, now remember, these emergency protective orders under Chapter 17 of the Code of Criminal Procedure, and there's a whole lot to protective orders. And it's confusing, and that's kind of the purpose of this deep dive. These protective orders that I'm talking about right now, the Chapter 17 Emergency Protective Order, are only good for 120 days, and they cannot be extended. They either have to be turned into a Title IV protective order that's filed in the district or county court with jurisdiction over the children and or victims of violence. That's a protective order that must be filed by the assistant district attorney, usually in the family violence division of whatever county you may live in. But these original emergency EPOs, they either end at 120 days or they turn into something else. Now, a lot of them will end, and sometimes that's a good thing, and sometimes you can even modify them to allow some flexibility. That's a pretty high burden to go back into a magistrate, and essentially you're the victim, you're there with your attorney if you have one, and you're asking for some restrictions under the emergency protective order to be lifted. Occasionally that will happen in cases of reconciliation, in cases where the parents, the spouses, whoever the parties to the family violence order are, have demonstrated to the court that they've taken some massive steps to fix whatever was going on. In other words, quit drinking, went to a battery intervention class, completed it, went to a parenting class, completed it, have gone to individual counseling sessions, have gone to joint counseling sessions with the other spouse. Don't wait around for the state of Texas to tell you what's wrong with yourself. Be proactive, get after it, and start fixing yourself if you have any hope of modifying this protective order or preventing it from turning into a protective order that's brought by the state prosecuting attorney's office under Title IV of the Texas Family Code. So more on that later, but again, you can modify them. That's the whole takeaway, but you got to do it by being extremely proactive, right? If you have any chance of doing it, you got to be extremely proactive, because you're going to have to go back in to the judge's court where the order was issued and say, hey, judge, I wasn't that scared the night that this EPO was issued, or, which is never going to work in my opinion, or you go back in there and go, I am the victim of family violence. This is my spouse. Look at all these great things that my spouse has done to get the family back together. We're going to just deal with the criminal case and criminal charges as they come, but we want our family back together. We want this order to be modified. If you're pretty close to the tail end of that 120 days, or you're just talking about some restrictions, so there's time with dad or time with mom, those will probably be granted as long as there's been some proactivity and some really, really outstanding behavior exhibited by the alleged the alleged violent spouse. So more to come on protective orders. It's an extremely complicated and I hope thought-provoking for you, the viewers. And anyhow, if you do have questions or comments, I love to get them. Please like, subscribe, and share, and I'll see you guys soon in the studio with more on protective orders in the state of Texas.